Thank you for joining us. Today we're sitting down with Will Knight, Maricopa County Attorney candidate. Will, good to see you.
Good to see you, John. Thanks for having me.
You bet. So, first, let's talk about you. If you could, tell the audience, tell me exactly, what's your history, what's your family history, what's your life history, and where are you as far as working in the legal field and all that?
Sure. So, I am a Colombian immigrant and an American citizen. I was born in a city called Popayan, a little bit south of Bogota. And my biological father was a drug dealer. He was down there working with the cartels. So my early childhood years were characterized by my family fleeing cartel violence. My family was kidnapped, trafficked, and held hostage because my biological father wound up deep in debt to those dangerous people, which obviously had a significant impact on me. But I also have personal experience with what it means to lose a relative to the carceral state. My biological father ended up going to federal prison for those things that he was involved in, and I never saw him after that. So those experiences inspired me to do the opposite, to become a prosecutor, to become a minister of justice. So I studied criminal justice in undergrad, and I moved across the country to the border here, Arizona, where I went to ASU for law school. I came here specifically because ASU has some of the best clinical programs in the country for training aspiring prosecutors. Specifically, they have a program called the Truman Young Fellowship, which in my research, I found that was probably the best program in the country. They only give it to one student every year. So I came out here. I also figured here on the border was the best place where I could be a minister of justice, where I could use my experiences and my judgment and my discretion to help people who needed help, like my family, and to protect us from the folks that we were afraid of. So it all just seemed to fit. I went to ASU and I worked my butt off. I ended up graduating second in my class overall because of that, because I wanted to get that fellowship, and I did. So I ended up having the privilege of protecting our community by working at the county attorney's office, at the attorney general's office, and the U.S. attorney's office. My first day at the county attorney's office, I was told by our predecessor to that office that I am too defense friendly because I had published some articles on prosecutorial ethics in the Law Journal and the Law Journal for Social Justice. So that was my first introduction to the hyper-adversarial culture that has grown up, particularly here in Arizona, but it's a microcosm of what's going on around the country and what has been for several decades during this tough on crime movement. This hyper us versus them, zero-sum game, law enforcement, tough on crime model, and I just couldn't do it. So instead, I started my career in private practice. I had the privilege of working at the law firm that took the lead in the fight to bring marriage equality to LGBTQ plus Arizonans. And that was such an incredible experience, probably the greatest professional honor of my career. And it inspired me to continue working in that space to deliver justice to people who had justice denied. So I started taking pro bono cases from the Arizona Justice Project, helping exonerate people who had been wrongfully convicted. And I absolutely fell in love with representing folks who didn't have an advocate, who had, in large part, never been treated with humanity or dignity by somebody in a position of authority and privilege, like a lawyer. So I just derived so much personal and professional and spiritual satisfaction from that I decided to leave the private sector and went to the public defender's office. And that's where I'd been for the last 4 years before this campaign, helping represent some of the most vulnerable among us and defend the rule of law, making sure that guilt or innocence would only be determined under the rule of law.
Okay. So you're running for the Maricopa County Attorney's Office, the diametric opposite of that current position that you're in.
That's right.
The other side of the aisle. You started as with a desire to be a prosecutor. You specifically educated and invested in being a prosecutor. And now you've worked on around this. So I understand why the rounded nature of your legal experience is valid. It's extremely valid. But why go back to the Maricopa County Attorney's Office? What is it about the MCAO that you want to work on? What sets you apart from the other candidates that are in the field right now?
Well, we have this incredible opportunity. Right. This was never part of the plan, but when our elected predecessor to that office was appointed and vacated it, I took a hard look at it and realized that here in Maricopa, the fourth largest county in the United States of America, which sits in Arizona, which is the fourth or fifth most incarcerated state in the country, depending on whose numbers you're looking at and how recent those numbers are. And this is the most incarcerated country in the world,
right?
In world history, actually, which is a frightening thought.
Right.
So we have a huge problem, a massive culture problem. We've had it for a very, very long time. This tough on crime movement, and this inextricable intermingling of our conception of criminal justice with law enforcement. We view our county attorney as our chief law enforcement officer, as the top cop. But what do prosecutors say when they announce in court, right? I'm John Fabricius. I here on behalf of who?
Yeah, the people of the state of Arizona.
The people, exactly. So prosecutors are actually supposed to represent all of us, not just one constituent group or one interest. And that's how it's always been. It's only in relatively recent history, since the post-civil rights era, which led to the war on drugs, which led to the tough on crime movement, which led to particularly vitriolic otherizing and demonizing here on the border. It's what led to the rise of SB 1070 and demonizing our immigrant communities. So all of that has led to the carceral state, because people have been using county attorneys' offices and DA's offices for decades to launch their own careers and to do what's in their best interests instead of what's in all of our best interests, because it's politically expedient. It's easy to point the finger and otherize, to demonize the bad guy, the criminal, and sell fear to get elected. Well, I'm running for Maricopa County Attorney to serve as your Chief Justice Enforcement Officer, to return to our foundational principles of limited government, of individual liberty, of satisfying our burden of proof, and of innocent until proven guilty. So when you represent the people, and that means that you represent, including all of us, right? So from a budgetary perspective, you need to think about how you handle justice in the best interests of the community. You also need to think about the person sitting in that chair, who is one of your constituents. And that's long been the state of how things works. It's baked into our law, too. Arizona law says that we are supposed to, it says the purpose of our Title 13, our criminal statutes, is to impose proportionate penalties, to differentiate on reasonable grounds between serious and minor offenses. Because one thing that all of us agree on, Republicans and Democrats, is that if you are touched by the justice system, whether it's because you are accused of committing an offense, whether it's minor, whether it's serious, whether you're victimized by a crime, we want it to be the only time that that happens to you. And we've set up this system that's been sold to us by people doing it for themselves and not the community, that has compounded the harm by incapacitating people, by saddling them with convictions that make them unemployable, by sending them to prison that doesn't help them reintegrate and doesn't rehabilitate. It only serves the purpose of punishment and retribution. And then those folks come back into society and they have no options. And so the cycle of recidivism continues, and it makes all of us less safe. So again, I'm running for Maricopa County Attorney to return to our foundational principles, to serve as your Chief Justice Enforcement Officer, and to end mass incarceration.
You know, to that point, Will, you're talking about that the Maricopa County Attorney's Office and really the Attorney General's Office, but any of the prosecutorial law enforcement in this state, there is a disparity between Arizona. I think it's built into our Constitution specifically that it shall be, I think it's Article 2, Section 25, it's been a while since I looked at it, but it requires the state to say the state of Arizona, as opposed to many other jurisdictions which say for the people, representing the people. Do you feel that that's baked in here in Arizona to try to divest the law enforcement from the people?
I think so. That's symptomatic of the cultural problem that we have, of the intermingling of justice enforcement with law enforcement, and our conception of the county attorney as our top cop, right? That's the exact purpose of doing that, and a lot of the things that we have passed into law do that same thing too. I 100% agree with you.
Okay. So we've got a long history. This is the home of Barry Goldwater. This is the home of John McCain, and this is the home of many of the GOP stalwarts. This has been a red state for as long as I can remember, and I'm a third-generation native. So it's specifically when we look at the Maricopa County Attorney's Office. The Maricopa County Attorney's Office has been held by the GOP or a Republican since 1982, I believe. What do you believe is the impact, not just of it being single party for that long, for over 4 decades, but also in the era of the GOP's paradigms of tough on crime policies, all the way from the national down to the local level? What's your idea of the impact on that?
Well, single party control is often problematic, and particularly when a single party has decided to demonize segments of our community for political gain, similar to the otherizing of the bad guy and the criminal under the tough on crime model, the SB 1070, and that rhetoric to demonize our immigrant communities and further disenfranchise our black and brown communities and make them afraid of our courts and afraid of law enforcement, to make other segments of the electorate feel safe and comfortable and happy and reelect you. That's super problematic whenever one side does that. But I really don't like viewing this as a Republicans or Democrats problem, because this is something across the country that Republicans and Democrats have been doing for a very long time. And to be honest, we really need to remove politics from justice enforcement too, because that's how we get to that space where we start trying to figure out how to advantage one group of our electorate, our constituents, our high turnout voters, versus everyone else who's probably not going to vote for you, right? When we use these careers or these elected officials for political gain to advance careers, that incentivizes the wrong thing. And that's why it's important to elect county officials, and particularly to elect chief justice enforcement officers who are doing this for their community, not for themselves. The GOP has been tough on crime, but so have Democrats. Across the country, for a long time, it's a successful model. In Philadelphia, Larry Krasner beat a tough-on-crime Democrat. He was a former public defender, and he ran to do the same thing I'm doing, but his opponent was a Democrat. The same thing just happened recently with my friend Chesa Boudin in San Francisco. He had a tough-on-crime opponent who pretended to be a reformer, who said nice things, but actually wasn't invested in bringing about cultural change, in departing from tough on crime and moving to a harm-based, data-driven, community-oriented conception of justice enforcement. So it's not strictly speaking Republicans and Democrats, and I'd like to see us start departing down the road from this being a partisan political office.
Okay, well, so one of the main aspects of the Maricopa County Attorney's Office is the working relationship with local law enforcement. Specifically for the Maricopa County Attorney's Office, you have the Phoenix Police Department, and you have the Maricopa County Sheriff's Office, and some of the other local Tempe, Scottsdale police departments that you have, some of the other ones as well. So let's talk about officer-involved shootings. In Maricopa County, 2017, we had around 40 officer-involved shootings. That spiked in 2018 at 82 officer-involved shootings, and it seems to have gone down now to about 44, plus or minus, officer-involved shootings. What do you think accounts for that change? Why do you think it spiked, and why do you think it's gone down drastically, like by 50%, in that short period of time?
I don't think that we can look just at the officer-involved shootings and the shootings involving that result in death to give us all the data we need to fill in that picture. It's incredibly important, and it is massively problematic. But when we're talking about such a small sample size, it doesn't give us enough information to get to the root of the problem. I think what's more important is to look at officer interactions with the community broadly, figure out where the problems are, why there are disparate involvements with our Black community, our Latino community, our indigent community, and then start to solve those problems, and hopefully we'll see the number go down, rather than focusing just on the number year to year, which doesn't give us enough information. So it's clear, though, that that's a huge problem. That's one of the big reasons why our communities of color, quite understandably, do not trust law enforcement. And that makes all of us less safe. Because when our communities don't trust law enforcement, they don't report crime. And when they don't report crime, then that means that dangerous people, that actual crime that occurs goes unreported. That those folks live in our communities and prey on all of us. Right. And nobody says anything about it because the relationship with law enforcement is so fractured and so damaged, and understandably. So we need to respond to that. In September of last year, there were 477 officer incidents of officers pulling their guns. That means there were more than 15 per day in September of 2019. That's insane. But if you look at that number, 70% of those incidents were involving people of color. They're about 32% of the population in Maricopa County is Latino, and about 7% is Black. 40% of them were officers interacting with Black people. So there's an incredible problem here. There's an incredible problem with racial disparities in the system, and we need to get to the bottom of it. I think there are 3 clear things we can do to work on that. Having a transparent Brady list is massively important. The Brady list is a list of officers who have been involved in issues, disciplinary issues indicating animus or bias, that then make it impossible to trust their credibility on the stand as a witness, and therefore you have to disclose that officer's disciplinary history to the defense. Practically speaking, what we should be doing is having no-call lists, and we actually do at the county attorney's office. Most prosecutors' offices have these no-call lists where they know who the problem actors are, and they have this secret list they don't show anyone, but they quietly communicate to law enforcement that we shouldn't have those officers sending us submittals. But it allows them to stay on the streets and continue working their cases, and they just let other officers take the lead on the investigation. So we need to have public no-call lists where we publish it. And I mean not just in response to public records requests, I mean on the internet. Like, let everyone know that we will not work with these officers because we can't do our jobs as lawyers if you don't give us credible, reliable witnesses who aren't tainted with bias. That'll put pressure on them to get the bad actors off the streets and to improve the relationship between our communities and law enforcement. We also need to hold our government accountable. That means when there's a tragedy, when an officer is involved in doing something wrong, it needs to be investigated, and it needs to be investigated independently. We have AZ Post certified law enforcement personnel at the county attorney's office right now. They're investigators. And a lot of the work they're doing is largely ministerial, and I think it could be put to better use. A lot of the good men and women that I know in law enforcement want that. They want that insulation from an independent investigation, so that if they're accused of doing something they didn't do, then a dismissal or a rejection of charges has that extra quality of truth and reliability for the community to trust and for them to trust. But it also separates and eliminates the possibility of abuse, of corruption. So the officers aren't being investigated by their office mate or the guy who was the best man in their wedding. Sure. So we do that. And the third thing is community oversight. I think that we need to partner with our community leaders. We need to partner with our grassroots organizations who have been most impacted by the disparities, and we need to create oversight committees, not just over law enforcement, but also within the county attorney's office, so they understand how we're responding to the racial disparities in the system. And when we partner with our communities, for example, with our universities, with social scientists, and we open the doors transparently to the data, then we will see that Black and brown people get charged more frequently, they receive more charges, and they receive more significant settlement prospects than other folks. And that's borne out by the statistics. Maricopa County definitely has the longest average sentences of everyone going to the Department of Corrections, but Black people, for example, getting sentenced out of Maricopa County have even longer average sentences than the average sentences in Maricopa County. So once we open the doors to that data at the county attorney's office and we see how it works, we can build structural changes to eliminate that implicit bias. I don't think we can train things like that away because people are not receptive to it. Sometimes there are folks who are intentionally doing it. Invidious discrimination still exists, but there are a lot of folks who just aren't open-minded to examining the fact fact that they might be contributing to this, that their implicit biases are impacting it. So structural changes, transparency, community partnerships, and holding government accountable is how we get to the bottom of that.
So let me drill down on a couple of those points. Will, you talked about a Brady violation. Why are we calling it a Brady violation? For any of the viewers that don't know what Brady was, what is Brady?
Sure. So Brady was a U.S. Supreme Court case that says it is prosecutorial misconduct not to disclose exculpatory evidence to the defense. So you can't withhold that information. And so that's one of the things that falls under Brady very squarely. If an officer involved in this investigation had significant credibility problems because they have a history of targeting a particular segment of the community, or they've been disciplined for falsifying evidence in the past, and that kind of thing, you absolutely have a constitutional right to have when you're sitting in that chair, because we believe in innocent until proven guilty and the government meeting its burden, due process, right? But that's also one of the number one reasons that we end up with habeas cases that are successful, because we still have a problem with those disclosures. So the transparent Brady list is going to help, but if we really want to eliminate the problems from non-disclosure of exculpatory evidence, is we need to move away from the Brady standard being our metric for whether we disclose things to the defendant, because it's too fuzzy a standard, and it's too subjective, and it puts the onus of determining what may or may not be exculpatory on your adversary, on the prosecutor. What we need to move to, and I think that's why it matters that I have civil litigation experience, is let's move to the standard civil disclosure rule. And what does that mean? Do you have anything that could lead to admissible relevant evidence, period? Then disclose it. If you're asking yourself as a prosecutor, should I disclose this to the defendant? Then the only reason you're asking that is because it might help. If you're asking that question, you're already 10 steps beyond the rule that I think we need to implement, which is this relevant? Hand it over. The government needs to play fair.
So you don't believe right now that the rules 15.1, 15.2, those rules right now are sufficient in the Arizona rules of criminal procedure?
I don't believe so. Okay. I think we need to move to a broader conception of what our disclosure obligations are. We need our government to hold itself to the highest standard. And if we are intentionally withholding anything for any reason other than very legitimate ones, like, for example, victim contact information, which there's a good reason that we don't publicize that we redact that.
Sure.
But that's no reason not to give over other evidence, not to redact those little parts and disclose everything that you've got. And that's why it's important to have a solid relationship with law enforcement, but also to have that separation so that law enforcement knows that you're in control of the case. Because right now, a lot of those problems happen not because we have horrible county attorneys. There are a lot of fantastic lawyers in that office. I've mentored many of them. I've been mentored by many of them throughout my career. When those problems tend to come up, they tend to come up because on the last day, right before trial, suddenly law enforcement hands the prosecutors a much bigger file. And we need to stop that. So we need better training to help our county attorneys work with the law enforcement agency as we would in any civil case with a potential witness or with a client that you're representing who could be in possession of evidence, and train them to give us everything they've got. Because constructively, just because it's in the hands of the law enforcement and we have good prosecutors who would disclose it if they had it, constructively it's in our possession, it's in the state's possession. And so it's our responsibility. It's incumbent on us to dig deep into the law enforcement offices who have all of that evidence and to gather it and disclose it.
Would it be a policy that you would initiate in your office if elected, that law enforcement would be required to have a finite date prior to the commencement of a trial, for say, that all evidence has to be turned over at that point, so there is no late day sandbagging?
I think, yes, I think that's something we could do, but I think the better policy is to just do it at the beginning.
Okay.
Because you can't make reasonable decisions about whether to settle a case or whether to go to trial, about what kind of a chance you have at trial if you choose to exercise your constitutional right to a trial by a jury of your peers, without having that full picture in front of you. And a lot of those settlement discussions, they happen early on. It also disadvantages our prosecutors from knowing the strength of their own case when they don't have everything. So we need to train our law enforcement officers about our obligations as lawyers. We need to hold ourselves to higher standards as lawyers, and we need to bring folks into that office like me who understand how to work with a client or a third-party record holder to collect that information intentionally, aggressively, and early, so that we can give everything out there, be as transparent as possible, and to be as fair as possible.
So there is issues, though. Let's look at it in a policy-wise. There is issues where you may have a dangerous criminal that law enforcement has a legitimate reason to want to get off the street. Prosecutors have a reason, but when you arrest somebody and you charge them, then you're invoking Sixth Amendment rights. How does that work with a continued and open investigation on trying to access all the information that law enforcement needs to successfully prosecute somebody? Where does that come down to policy-wise? Because you, as the Maricopa County Attorney's Office, are going to have to set policy on how we referee the handling of Sixth Amendment rights for defendants as opposed to investigation rights for police, and getting people off the street that may be a harm to society.
I actually think one of the biggest ways that we run afoul of speedy trial rights is by late disclosure. So by creating better policies and training and working with our law enforcement agencies for them to understand these obligations that are going to be broader and more transparent early on, we will mitigate a lot of the need to ask for continuances. And in Arizona in particular, the right to a speedy trial is very important. But in Arizona, we have really robust rules of procedure that are even more robust than the constitutional standards. So it's pretty strict. When you're talking about ongoing investigations, obviously, if you don't have the information, you don't have to disclose it yet. That's a legitimate reason for something to be disclosed later on. And the decision needs to be made then by the parties, which includes the defendant who holds the right to the speedy trial. If that new information that just came out, whether they want to delay trial to do further investigation in response to it, or if they want to accept it and proceed right to trial. But that's a legitimate reason for a late disclosure. If you didn't have it, you don't have to disclose it. But we also need our officers to be investigating diligently. We can't have any gamesmanship where they don't collect information for strategic reasons until later on. So that's problematic too.
So if elected, you would be bringing with you the most progressive policies that the county attorney's office has had in 4 decades, by definition. Are you concerned about the potential discord that you would have with line prosecutors that have been in there and are career prosecutors in that office, and with a relatively conservative law enforcement agencies throughout the Maricopa County cities and at the county level?
Not at all. And let me take those one at a time.
Sure.
So I mentioned before that I believe there are the vast majority of people who get into criminal prosecution or who go into law enforcement do it for good reasons. Like me, my life was impacted by crime. I know firsthand what it means to live in fear because you've been a crime victim. And a lot of folks have similar stories that get involved in these things, and they do it because they care, they do it because they have that perspective, and they do it because they want to help our community, right? So I think our line prosecutors for years have been disserved under previous administrations, and the administration before that with Andrew Thomas, and then before that, by giving them strict black and white policies. That's part of the tough on crime thing. It says if somebody has X criminal convictions in their history and they are accused of Y crime, then we charge absolutely everything. We allege the absolute maximum every time, and they give you a prosecute by numbers policy handbook. So that strips discretion from the line prosecutors, and frankly, it treats them not like lawyers, but like administrators. Like just point and click, do it my way. And it kills the passion of folks who got into this because they wanted to help their community and they wanted to do justice. So we need to get rid of that. And I think even the folks who might not agree with me politically are going to be extremely happy to not be operating under a strict black and white policy manual, to be operating under a harm-based calculus of how to do justice and do what's in the best interests of the community. And to know that they have a leader who will never, under any circumstances, throw one of them under the bus because they have given somebody a chance, because they have attempted to use our justice system to help resolve the problem, and they didn't view prison as the necessary solution to redress the harm that happened in that case. And that's critically important. When you have somebody doing this for personal gain or to advance their career, that's what they do. They throw the line prosecutor under the bus because they weren't able to secure a high enough bail to keep that person in jail pending trial, or they throw them under the bus for not getting the important conviction for someone that then later did something else. That's incumbent on the elected official. It is my responsibility when I'm county attorney. If something happens, if there's a tragedy, if life happens, to stand in front of the electorate and to say, that was a tragedy. My heart is with everyone involved, but we're not going to change our policies and depart from our historic founding governing principles just because of that tragedy. And if it means you don't get reelected, so be it. That's why we have elected politics. So I think our prosecutors are going to be extremely happy, whether they're Republicans or Democrats, to know that I trust them and that I am inspiring them to do justice. As far as law enforcement officers, I'm not delusional. I don't think I'm going to be endorsed by a lot of large law enforcement agencies, but I know a lot of law enforcement officers. I know a lot of good men and women who work in that field and who protect our communities. And I can tell you, they're sick of a lot of stuff too. They're sick of being treated as our dumping ground for our society's mental health crisis. They're sick of being a shuttle service for folks suffering under our other public health crises, under our opioid crisis, or other substance use disorders. That's viewed largely as a waste of their time, particularly when we're talking about nonviolent, non-dangerous people. And I think, in large part, once they start working with me and they see that they have an ally who maybe doesn't want to do things the traditional way, but still believes in them and trusts them and wants to improve their relationships with our communities by holding the bad apples accountable and by empowering them to do what they're supposed to be doing, which is focusing on real, actual crime, then I think those relationships will improve, even if they don't want to endorse me on the front end.
Okay, so let's shift gears a little bit, and let's start talking actually about the prosecution and the Maricopa County Attorney's Office specifically. Can you describe your vision for juvenile justice in Maricopa County? Specifically, how might you use your authority as Maricopa County Attorney in deciding whether charges are pursued in juvenile court versus an adult court?
So this is part of the culture change that I'm talking about bringing about, right? What is the harm that occurred here, and what is the just result? A conservative U.S. Supreme Court, Miller, Montgomery, and the cases that came after that determined that it is fundamentally unconstitutional to sentence a juvenile to life in prison because it is cruel and unusual under the Eighth Amendment. Young people are not fully developed. They have so much capacity to be rehabilitated, to rejoin society, and to be positive contributing members who help fix the problems instead of making them worse. And because they have such diminished capacity to appreciate the consequences of what they're doing when they're young. So bottom line is, if we have discretion whether to prosecute children as adults or in juvenile court, we leave it in juvenile court. Right? Where we don't have discretion, where the law says clearly this is the type of offense that occurred and it must be prosecuted as an adult, then we have discretion on how to charge it, and we have discretion on how to settle it in a way to set that juvenile up to succeed. Particularly with young men, the young male brain is not fully developed until about age 25, and that has been borne out by repeated, peer-reviewed, replicated studies. Yet at our county attorney's office right now, the current interim appointee is doubling down on efforts to undermine that science so that they can continue sending juveniles to prison for longer rather than setting them up to succeed.
What do you think that is? Let me ask you real quick, why do you think that is? Why if there's Supreme Court jurisprudence on this,
From a conservative Supreme Court,
from a
too, I
very
think.
conservative Supreme Court, and it wasn't a 5-4 decision, I believe, in Miller, right? So why is a county prosecutor? I don't want to put you in the shoes of having to answer for that, but what is
I'll
the
answer
game?
it.
What's the game here? Why there's jurisprudence on this from the highest court in the land? What's the game?
Because it's the tough on crime culture, right?
Okay.
First of all, as lawyers, right? Lawyers like being lawyers. Lawyers like litigating. They like the adversarial process, and they like winning. It gets
Sure.
competitive, right? But that's part of the problem. When you represent everybody, you need to do what's in everyone's best interest. Being a minister of justice means you can strike hard blows, but never foul ones, right? So the culture problem of the tough on crime era still exists in that office today, and the hyper adversarial nature of just litigation and the way that gets exacerbated and exponentially spun up because of the tough on crime culture leads to that. It leads to us looking at a case where we have a juvenile who is involved in a very serious offense and going, that's a criminal, that's a gang member, that person is an other, and they have no value to add. In fact, I think they're going to be dangerous forever, and so let's send them to prison. And then the lawyer in you says, why don't we try to change the law? Because that's something else you can do as a lawyer, is to persuade the courts, the appellate courts, and particularly the U.S. Supreme Court, to depart from precedent or to make new exceptions, to cut back on things. That's also why we have slowly been losing our Fourth Amendment rights. Prosecutors keep litigating exceptions to the exclusionary rule over and over and over.
Yeah.
And so it's all part of the same thing. It's cyclical. It's part of the culture problem that we need to change.
Okay, so let's stay with juveniles for a moment. There's a disproportionate number of juveniles of color involved in the juvenile justice system. What policies would you put into place to ensure fair and unbiased use of prosecutorial discretion in juvenile court?
So we need to stop politicizing our justice system, and we need to repair the divide between our law enforcement agencies and our communities of color. I think holding government accountable is one of the ways that we accomplish that. I also think, I mentioned before, we can build structural walls to help reduce implicit bias that's baked into the system. Fundamentally, the school to prison pipeline is fed by the fact that we view young black and brown men and women differently. They are otherized, and that they are perceived as more adult or more dangerous than they are at their age. So we need to work with our schools to get rid of this system of over-criminalizing and over-policing our youth with resource officers. Jeannie Castine, who's running for Maricopa County Superintendent, understands this very well, and I'm looking forward to partnering with her once we win these elections to do that. But that's not, strictly speaking, within the role of the county attorney.
Right.
I can help with that, but that's something we need smart government officials across the table to understand, to help redress. At the county attorney's office, in general, with relationships between our communities of color and law enforcement, the structural change that I'm going to implement is to create a division to handle all submittals from law enforcement agency that is separate from the charging attorney. Now, it's not a division of attorneys. I mean, paralegals and investigators who can pull all the submittals, do all of the background investigation that you need to make decisions in cases, and then redact the names. And anything that identifies somebody's ethnicity or background in that way, and replace it with something very mundane, like suspect, right? And what that's going to do is it's going to force us not to default to the implicit biases that are baked into the system. And on the back end, with the transparency that we're going to bring to that office, when you see us do that, you're going to see, I think, the numbers are here at the beginning, and then after we do that, the numbers are kind of a little more balanced out. That's not going to fix the problem by itself, but it's one big contributing factor. I'm also working really, really hard with our community organizations, our grassroots organizations, who have been most impacted by the current system that we've been living under for the last several decades, to earn their trust. And that's critically important, because when you have a trust gap between law enforcement and those communities, and you're running for an office that's historically been viewed as a chief law enforcement officer, they're not going to want to work with you on the back end unless you earn their trust. So I've been working really, really hard on the campaign trail to earn their trust. And when we win this office, we're going to plug them in to our oversight committees, and we're going to listen to their perspectives and opinions every single day. And we'll have regular scheduled meetings, and voices will be heard, and answers will be given, even if they're not always the answers we want. But we will engage them and make them part of the process. And that trust that we earn will enable us to enact new policies that otherwise nobody would ever take advantage of. I mentioned before that dangerous people live in our communities of color because our communities of color don't trust law enforcement and therefore don't report crime, right? And it makes all of us less safe. So we can use those AZ Post certified officers at the county attorney's office to petition the federal government for witness cooperation visas, for crime victim visas, and keep control over how we define cooperation rather than leaving that in the hands of law enforcement agencies where it really shouldn't be, because they're not the lawyers behind these cases. So we can keep control of that, and then we can promise our immigrant communities that if someone hurts you, or if you see someone hurt someone else, you do not have to be afraid of court. Court will be here as a safe place for you. But nobody will accept that. Anyone can implement that policy. I give it freely to any of my adversaries. Try it. But they're not going to take advantage of it unless you earn the trust of those communities first. And that's what I'm working hard to do now.
Okay. So we've discussed a bit on juveniles, and of course that leads to a bigger discussion about families. So research indicates that families thrive when they're able to remain together. Presently, issues including cash bail, prosecution of low-level nonviolent offenses, and the stacking of charges. Stacking of charges is a big one. In order to reach a felony level, all contribute to the separation of families in scenarios where public safety is not at risk. As a Maricopa County Attorney, how would you work to remedy these issues in order to keep families together and allow these affected individuals to remain positively engaged in the community?
You said cash bail, something else in the second charge?
We were talking about cash bail, prosecution of low-level nonviolent offenses, and then the stacking of charges to reach felony levels.
Absolutely. So the cash bail system is massively problematic. It's inequitable. Only the wealthy have access to getting out of custody. But it's also something that we've studied. People don't realize this. It's on my campaign webpage if you'd like to download the document, night2020.com. There was a task force created by Chief Justice Scott Bales, who vacated that office recently. Unfortunately, he was a fantastic jurist and a great leader. But he commissioned a task force that issued a report in 2016 called the Task Force on Fair Justice for All. And they took a real hard look at fines and fees in the system and the impact of our cash bail, our money bail system. And they learned what you probably know very, very well. And it's important to know also, before I tell you what they learned, that this commission was comprised of Republicans and Democrats, of stakeholders across the board, of prosecutors, defense attorneys, judges, people from the jails, people from the bond and bail industry. So Chief Justice Scott Bales was very, very smart, and he did that to give it the extra credibility that it would need. So all of those folks worked together to study this, and they determined what we know very, very well, John. They determined that cash bail makes us less safe, that when we erode our fundamental principles of innocent until proven guilty, and we put people in jail when they are innocent because they haven't been convicted yet, that it makes us less safe. After 72 hours, lives are so thoroughly destroyed. People lose jobs. People lose homes.
Right.
I've seen it. I sit on the Commission on Access to Justice, where we're trying to solve the eviction epidemic that we have right now that is fed by this. People lose homes. People lose relationships, and it just destroys families. So we need to depart from that. We need to get away from a money bail system, and that's a day one priority for me, is that we stop asking for money bail in the vast array of cases that we have in that office. And we need somebody who's not a politician on the back end to defend those policies to the electorate, because life happens and it will happen again. Low-level offenses, that's also a huge problem. We send people to prison for shoplifting, as you know. A woman just died in Perryville prison 2 weeks ago, who was sentenced there, serving a 2-year sentence for shoplifting because of the inadequate medical care that we have in those prisons. But prison for shoplifting is kind of an insane concept, right? It's a misdemeanor too. So the reason, the way we accomplish that is by some insane laws that we've passed during the tough on crime era that help us treat shoplifting like a felony when it isn't or it shouldn't be, and some legal fictions where we've converted it into a felony. For example, if you reach behind the counter and take a pack of cigarettes instead of some potato chips from the front, we call it a burglary. It's a class 4 felony. We send people to prison. If somebody puts something in their purse instead of their pocket, that's shoplifting with an artifice. That's a class 4 felony. We send people to prison.
Right.
And if somebody's stealing something to sell on the streets because they've been so incapacitated, because they have mental health issues and they can't find employment, well, that's trafficking in stolen property. It's organized retail theft. Those are class 3 felonies, as you know. We send people to prison for a long time for that.
Right.
So that's got to stop. That's a day one priority for me. We stop prosecuting, and that harkens back to the purpose of our laws. This is in the Arizona Revised Statutes, Title 13. The purpose of this title is to differentiate on reasonable grounds between serious and minor offenses. Our elected officials swear oaths to uphold the law. But those kind of aspirational laws that don't have teeth are the ones that first get ignored in a tough on crime culture. And so we return to that. And that's going to help families stay together. And it's going to help. Now, I'm not pro shoplifting. Like, trust me, I'm not footed by a pro shoplifting lobby. I just think if the harm, again, the harm in the case is a $3 Twizzler stick stolen from a gas station, then the just result is certainly not that all of us as a community spend $25,000, $30,000 per year per person to send somebody to a prison where they don't have adequate treatment or care, where they are further criminalized, where they have access to substances because our jails are not safe places and they don't offer rehabilitation services. And then when they get out, they're further incapacitated, and it increases the cycle of recidivism. That is fundamentally problematic for all of us. The last thing you asked me about, I think, was the stacking of charges. Also fundamentally problematic. Our law enforcement officers have learned from the prosecutors during the tough on crime era that we'll do that we will stack as many charges as possible, one day, the next day, the next day. And I saw this. I did most of my work in indigent defense and fraud work. I was in the major fraud division in that office. And I saw a lot of folks in that office would charge cases every single day as a separate offense, even if you had an ongoing allegation of a fraud scheme. And so every day would be a new Class 2 felony for a fraud scheme and a new theft that would be a felony if it were over $1,000. And when you have it on multiple dates of offense, as you know, that increases your exposure all the way up to Category 2, even if you're a first-time offender, which raises the mandatory minimums. So that's absolutely got to stop. There was a fantastic bill at the legislature just last session that tried to stop that, and it had massive bipartisan support. I think it was even proposed by a Republican group called Right on Crime, and that was tanked at the last minute because our county attorney used his bully pulpit to persuade the governor to veto it after it had that broad bipartisan support. That's absolutely got to stop, and that stops day one under my administration.
So these things break down to elements, and this is one of the things I wanted to drill down onto with you before, some of the comments that you had. I mean, you're just talking about elements. Some of my experiences that I had seen is taking your fraud example, is a person, one individual conduct, and because the elements are so broadly written, any gain from any artifice, fraud schemes, theft by misrepresentation was 2 charges and was able to get a 9-year prison sentence and a probation term after that based on the same underlying conduct. That's an incredible tool for a prosecutor. It's one thing to be out here in the abstract on this side of it. When you're in there and your office is required to put lawbreakers in prison, how do you not use those tools?
Well, one, I want to correct something. That office is not required to send anyone to prison. That's the discretion of that office when that is the just result, whether to do it or not. Okay. But tell me again, what exactly is the question you're asking? How do we not do that?
It's one thing to say out here in the abstract that we want to change these policies, but when you're in there and the job is, if it's not sent to prison, it's definitely to convict lawbreakers. How do you stop from using that power? What controls will you have in place as an administrator of that office to stop a prosecutor from charging somebody with fraud schemes and theft by misrepresentation, as an example, for the same conduct, which is the individual stacking of charges? What policy are you going to implement on that?
Okay, so this is part of the cultural change that we need to implement, right? And the way I view it is that we staff up, we don't deviate down. Day one, we stop using prior convictions for simple drug possession as priors, and that's going to help. We also create a policy that says if you can charge offenses under multiple different statutes, if you can charge it under, for example, fraud schemes and artifices, which is a Class 2 felony, or fraud schemes and practices, which is a Class 5 felony, then absent really, really good reasons, like we got Al Capone, but we only got him on tax evasion, right? Absent some really good reasons that you can stand up in front of your colleagues who understand this harm versus just result calculus and defend your decision to try to use the law to increase someone's exposure, then we don't do it. We simply don't do it. If there's a lesser offense that you can charge, that's the standard. So we staff up instead of deviating down.
Okay.
And when we change that culture in that office to depart from tough on crime, because you can indict a ham sandwich, right? So we stop charging every single offense that we can. There's still a federal crime on the books that says you can't travel interstate with a pair of dentures unless you have a doctor's note. That's a federal offense. We've passed so many laws that anything can be a crime. And when you view that office, and I think you still said this, your job is to convict people who committed crimes, that's also not necessarily how you're supposed to conceptualize it, because if you do, then that's how you build a culture of prosecutors who only charge, they look at a report and they charge every offense they've ever seen. And people who are accused of offenses, this is manifestly unjust, and they struggle so hard to understand how and why this is what's happening to them. I know it because I've represented so many people in that situation, and for them to understand that the government, that they did a wrong thing, sure, but the government is now playing games with it and using it to jack up the consequences for them. It's difficult to comprehend why. When as a first-time offender who's nonviolent, non-dangerous, you're not getting an opportunity to try to do better. So we change the culture by doing that. Staff up, don't deviate down.
Okay, so presently the MCAO offers diversion programs for both juvenile adults, including drug diversion, felony pretrial intervention program, the justice court diversion, etc. What is your opinion of the efficacy of these programs as they stand, and what changes would you implement within the programming if elected?
I don't think they've been very effective. I've represented over 1,000 people at this point who've faced felony charges in Superior Court in Maricopa County, and I have accomplished FPIP, which was established under the previous administration. I've gotten that twice ever. Most of the time, I'm told by line prosecutors that they don't really understand how it works, and so they don't want to try it. And that's part of the culture problem, right? When line prosecutors are encouraged to believe that it will be harmful for their career, that it's not the right thing to give people chances. They don't even want to learn about them. And they don't want to give people chances and use the resources that we put in front of them. And that's why some of the policies that we're seeing right now, some of the changes being implemented in that office by the interim appointee who's going to be running on the Republican side for this office this year, are not going to be effective. We've had FPIP in there for well over at least a decade, and 2 out of roughly 1,000 that I've been able to get it done. Because in the new policy to not force prosecutors to get supervisor approval when they want to deviate down. It's still a deviate down policy instead of a staff up approach, instead of a harm-based calculus. It's still tough on crime. And so that sounds good, right? That we're not going to force you to get supervisor approval. You can make those decisions in some of these cases, but that's not going to encourage people to take a different approach. It's not going to encourage our prosecutors to do justice. Cultural change is what's required to make that work. So FPIP hasn't been successful, and it won't be until we bring about cultural change. But I think it's a great idea. With the other diversion programs, primarily related to substance use disorders and things like that, Those have been massively problematic. There's a huge lawsuit that the county attorney is facing right now for creating those diversion programs and operating them in a way that is fundamentally unfair and inaccessible to vast segments of the community. If you're indigent and you can't afford those fees, then that's not a meaningful, real diversion program. You can't actually get substance use treatment and avoid being incapacitated by a conviction. It's another inequitable structure that only the privileged, only those of us with means and wealth can take advantage of. And so that's fundamentally unfair. The office is trying to ameliorate that right now. There are new policies about eliminating some of those fines and fees, but it's still a rigid, inflexible structure that is incredibly difficult for some folks who are struggling and who need help and treatment to be able to manage right out of the gate, first time, no problem. So we need to create meaningful, accessible diversion programs. And that needs to be individually tailored because justice is not a one-size-fits-all situation, right? So we need to empower our line attorneys to learn the full range of their discretion under the rules that allow us to suspend prosecution so that we can implement diversion programs and provide a wealth of different mechanisms that can be used depending on what that person who's contacted by the justice system needs. You can have a diversion program that literally is just go to college. Take a semester of school in community college or finish your GED, and that's all, because it's incumbent on the prosecutor to file the motion that says we're going to suspend prosecution and why. So we have absolute control over that. And those rigid programs and policies that have been in place forever now are not going to suddenly just become magically successful because we've eliminated the initial filing fee or we've given prosecutors permission to use them. We need to bring about cultural change, and we need to bring more resources, broader resources to bear so that we can stop using a one-size-fits-all approach.
Okay, so let's discuss the felony murder rule. Correct me on this if I'm wrong for the Arizona statute, but felony murder is defined as the engagement in a predicate felony where a death results. And so what that means is that two people can be going down to the Circle K and they're going to do a beer run or something like that along that nature. And if one of the two people shoots the clerk at the Circle K and that clerk was to die, both of them can be charged with first-degree murder and can be subject to the death penalty, and both of them can be subject to natural life in prison. Where are you at with the felony murder rule? Do we need the felony murder rule? Is it just? Is it fair? And is it equitable in our system of governance?
That was an incredibly succinct summary of the felony murder rule and what that statute allows. So 100% accurate. And that fact pattern that you just laid out is a very common one. Let me give you another one. It's three individuals, three young men, 18, 19 years old. They've been struggling. They're not from a privileged part of the community. They don't have a lot of resources or supervision. They didn't finish high school, and they're making the wrong choices. So they decide to go on a beer run, right? Because they're under 21, they can't buy it themselves, they don't have money. Very common thing. And a beer run, for anyone who doesn't know, that's when young people run into a gas station and just steal some beer. They just grab it and run, right? And instead of it being the clerk who gets shot, it's one of them who gets shot by the clerk. And one of the people was just sitting there in the car out there. And this wasn't the plan. It's a tragedy. Absolutely, it's a tragedy. But that person who was just sitting in the car, who thought his friends were just going to run in and get some beer, the operative language is a death occurs, and that's any death. So the felony murder rule is massively problematic, and it is one of the biggest ways that we have sent young men and women to prison for life and put them on death row when they haven't committed murder. So it's fundamentally problematic, and it's symptomatic of the tough on crime era, where we've passed more and tougher laws and demonized and otherized instead of trying to get to the root of the problems that are causing crime. Education and opportunity are the only things I'm aware of that consistently, statistically reduce crime and recidivism. So we do not need to use the felony murder rule, and we should not be using it at all. And our legislature should be very seriously considering getting rid of it. If you're a prosecutor and you can't prove murder, then you don't charge murder.
So broadening out from the felony murder rule, let's talk about the death penalty. What, if any, problems do you see with the death penalty in the state of Arizona as it is right now?
So the death penalty has a lot of problems. We've had the death penalty for a long time, thousands of years, and we're still talking about it because of a lot of those problems. It's incredibly costly, and it really disserves the victims, not just in that case, but in other cases. So let me explain. First, on average, it costs about $1.5 million to $5 million to litigate a felony case to fruition, to the end. And that's because it takes 20 plus years sometimes to go through the full appeals process through the state courts and then through the federal courts in habeas and sometimes back and forth. So it takes a long time, and it needs to take a long time because there's nothing more fundamentally un-American than executing an innocent person. And yet we've done that. We know we've done that. We know we've gotten it wrong now. We have the data. We've been tracking exonerations for the last 30 years. The National Exoneration Database has cataloged over 2,500 exonerations for serious offenses, and I think roughly 150 or 160 of those have been capital cases. That's people who were facing execution that have been exonerated, and that's just since we've been tracking it. Imagine how many of those folks never got exonerated, because that's one of the hardest things to accomplish as an attorney, is to exonerate somebody post-conviction. I know. I worked with the Justice Project. I've been working some cases my entire career, and we don't know where they're going to end up. So it's massively, we need the time, right? We need that time to do our best if we're going to use capital punishment so that we don't execute innocent people, because we know we can get it wrong. So we can't just shorten the length of time. So there's cost, right? And that's massively problematic. But think about the victims. What happens to the surviving relatives in that case during that 20-year period? Well, they have no finality. They spend that entire period in fear that the next appeal, the next habeas process, is going to overturn this conviction and force them to relive that horrible, awful trial again, or, God forbid, release the person who hurt their loved one. And I can't imagine living in that kind of limbo for that long. So there's no finality given to the surviving relatives in the murder case. And then finally, resources separate from money. That takes a lot of talent to do that. That takes a lot of talent for 20 years. Very experienced prosecutors need to spend a boatload of their time working on those cases to get them to fruition the right way. And what that does is it pulls the most experienced prosecutors, the most experienced trial lawyers and murder lawyers. It pulls all of them out of the regular trial groups and homicide divisions in that office to focus just on that, to focus just on achieving the death penalty. And so then we have other homicide cases where even if you're very, very pro-death penalty, not all cases fall within the realm of death penalty scrutiny. So there are other homicide cases, and those are super important cases too. Those are cases where somebody's taken another person's life, where somebody's lost a loved one because of the actions of another person. So those are real victims too, and they deserve justice. But with all the talented attorneys working on those death penalty cases just to get it over the line, to get to the execution, then a lot of those other homicides are being handled by very young, very inexperienced lawyers. And they're doing their best. They are. But defense attorneys are running circles around them. I've seen it, and they're getting acquittals. And that's justice too, because the government has to meet its burden before it convicts someone, but it's a massive miscarriage of justice to the relatives of those homicide victims who don't have a government working hard or effectively or allocating the right amount of resources to achieve justice for their loss and their tragedy. So at the end of the day, and this is why this is really important, what you're doing, John, we need to educate the public. And when I tell people that the only alternative a judge has to the death penalty, so if you don't seek it or you don't achieve it, like in the Arias case, which cost us over $6 million and they failed to get the death penalty, what's the only other sentence a judge can give in Arizona? Do you know?
Natural life.
Natural life. That means that at least from a community safety perspective, that there's no issue there. If you don't achieve or you just don't seek the death penalty, there's no problem there. That person's going to be away from us. It's not going. They're not going to be involved in the community. So when you think about all the costs, all the pain that it causes victims, the cost in other homicide cases, just the money, right? And the fact that we've gotten it wrong and we will get it wrong again. The difference between that and the death penalty, that's the difference between vengeance and justice.
So you mentioned exonerations, and exoneration in the context with which you're speaking is somebody that was convicted and through some sort of appellate process or post-conviction relief process, be it PCR, Rule 32 in Arizona, or habeas corpus at the federal level, in some way in that process, they were found that there was some sort of error in the underlying trial or underlying plea process. Maybe they had ineffective assistance of counsel, some error that occurred below in the underlying process that led them to their conviction, and then they've been released, or they were factually innocent. And that's a whole other that's a breed right there. But our current system, for a lot of people that don't know, that have never done any PCR work or appellate work or been exposed to it, is that a lot of people don't understand that the courts themselves are mandated by common law and by judicial procedure, that they have to look at these things in the light of upholding the underlying conviction. That's definitely happens in direct appeal when they review. And then there's other issues, things called harmless error, where there can be underlying errors, but the court has determined that they are harmless, ultimately harmless, and don't lead to an exoneration or an overturning or a new trial or something like that. Can you speak to that? Is that good policy? Is that good judicial policy? Is that equitable and fair in our system when we're talking about death penalty and we're talking about exonerations or natural life in prison and exonerations?
Boy, that's a really important question, and it's a difficult question to answer. Is it fair to the innocent who are convicted? Absolutely not. Is it fair to people who did have errors in the process, who did experience problems, but it was deemed later to be harmless? It's also not very fair to them. But that's how our courts operate. And our courts get to decide how they operate. Only the highest court in a jurisdiction can tell the courts to change the way that they operate. It's a judge's obligation to follow the law, and case law is the law. I know a lot of jurists who don't like it. They don't like that that's what they're obligated to do, but that's what they're obligated to do. And I don't blame them for that. That's the job of a judge, is to follow the law. I'd like it for our judges on the highest courts to start thinking critically about how to reform some of those systems. But in general, it is a little unfair. It's a lot unfair. But it's incumbent on some very smart lawyers who are now wearing robes to think really hard about how to fix that stuff. And I'm happy to work with them and help them do that to the extent that I have the ability to do so. What do we do on our end, though, as prosecutors to address it? I think we need robust conviction integrity units that, rather than stopping at all costs to prevent the examination of error, they facilitate it. And in fact, follow the clues when they start seeing errors, when they start seeing, oh my goodness, we have a whole bunch of cases here where it looks like the law enforcement agency involved, or specifically the detective involved, seems to have withheld evidence. And then you see that person, there's a problem in the system there, and then you can find other instances of injustice and aggressively go out to redress some of the harms that have occurred in the last several decades of the tough on crime era.
So, Will, you've mentioned conviction integrity units. Is that something you want to implement in the MCAO?
Yes, absolutely, and that's something that we need to be doing across the country, period, to redress some of the injustices, all of the injustices that have occurred in the last several decades of the tough on crime era. So while judges have to follow the law, particularly the law of the higher courts, and that's why it's incumbent on those smart judges at the top of our jurisdictions to start thinking about smart ways to fix those sort of processes that make it a little hard and make it a lot unfair for people to achieve justice if they've been wrongfully convicted or there were errors. But as prosecutors, we need to stop fighting tooth and nail every single case, every single habeas appeal, every single PCR. We need to have a robust conviction integrity unit that actually takes a vested interest in examining these issues and getting to the core of the problem. When you see that there are repeated errors coming out of a particular agency, and then you see that it's a particular detective or officer who seems to be problematic, then you need to have the capacity to take the proactive step to then investigate further. Do we have a real problem actor here who has been withholding evidence in multiple cases? Are there more that we don't know about? When you are the chief justice enforcement officer of a jurisdiction, it is incumbent on you to investigate and redress past injustices too. Yet right now, prosecutors fight tooth and nail no matter what, just to sustain convictions, as if they were the judges that have to operate under those harmless error standards, and they're not. Prosecutors that's not their responsibility. They're a litigant, and their responsibility is to their client, and that is the community. That's the people, what's in all of our best interest. There's nothing more fundamentally un-American than letting an innocent person stay in prison. So we have to investigate all of those things, and that means that we need smart men and women to come work at the county attorney's office who understand the appeals and habeas processes and are willing to do that incredible work. DNA, for example, is one of the number one things that our prosecutorial agencies dig their heels in on and refuse to cooperate. Yet, if you're at the point where you're past the normal PCR process, you're in habeas litigation, and somebody's generated the interest of an organization like the Innocence Project or the Justice Project, because you don't get free lawyers at that stage. So a lot of resources that get raised from the community that understands these problems and is trying to solve it get spent on those cases. And if there's that much scrutiny and attention on it right now, that's because there's something there. And hiding the light, hiding the truth is not how we achieve justice. So that's a basic one. If they're willing to pay the DNA test, and there's any colorable reason why these agencies are involved in it at this point to help somebody who can't even pay them, then it's worth taking a look. Why not? Why fight truth?
Okay, let's broaden it out to sentencing. We've talked about underlying convictions. Let's talk about sentencing. Under the Arizona sentencing scheme, a person with one or more prior felony convictions is sentenced to an enhanced sentence bracket. In addition to that, aggravating circumstances can be applied to that enhanced sentence to increase it based on the prior felony conviction. So to clarify that, I want to just give a little bit of an education for a moment. So Arizona's sentencing scheme has three brackets. One for no prior felony convictions, one for if a person has one prior felony conviction, another bracket of two or more. And that's changed, the language has changed, but in essence, that's what it's been for a number of years. And in that, they're enhanced sentence. So if someone has a class 4 felony, say a forgery class 4 felony, with no prior felony convictions, they would be facing a presumptive term of 2.5 years. If they have one prior felony conviction, I think the presumptive is 4.5 years. If they have two or more prior felony convictions, the presumptive jumps up to 10 years, if I'm not mistaken. It's been a while since I looked at the statutes.
That's correct.
So in that, they're already, for a prior felony conviction, they're already facing significant jeopardy, significant amount of time in prison. But under our sentencing scheme, and this has been handed down as being legal, prosecutors are given a second bite at the apple, in my opinion, which is that they can then turn around and seek the court's aggravation on that sentence based on that prior felony conviction. So they get an enhancement and they can get an aggravation term on that. Is that something that you want to continue in the Maricopa County Attorney's Office?
No, that is one of the hardest things to explain to somebody when you're defending somebody who's in that situation, is that the government has that power. The government can use something both to enhance their exposure and to argue that they should get the highest sentence of the range there. It's really unfair, and it's got to change. But there are some problems, mechanical problems with changing that, because that information is going to come out, and the law allows for it to be determined. At the end of the day, the judge decides sentences unless you've settled the case, unless the prosecutors have agreed to enter into it with the defendant a specific, agreed upon term that the court says is okay. So if the court has discretion of what to do with the sentence, then the court is also going to do a background investigation, right? Every single case goes through the adult probation department, excuse me. and it results in a pre-sentence report that goes to the judge. That's completely out of the hands of the defense attorney or the prosecutor to stop from happening, because that's an arm of the court.
Certainly.
I think we need to revisit that process and work with our courts to examine it. But the fact is, the criminal history is going to come out. They do a full FBI background check, and if somebody's already in a certain category because the prosecutors have filed the allegation and met their burden of proof, then the court has the power to examine that and consider it. So the only way we can respond to that as prosecutors, since the court's going to get that information, is to again, engage in this culture shift, depart from tough on crime, move to a harm-based, community-oriented justice calculus. What happened here? What needs to be done to redress that? What achieves us justice? And if it would be unjust to put somebody in a higher sentencing category and make them face prison when the court's already going to be aware of those priors in this category, then we don't file those allegations. We don't have to. Right now, the practice is to file every single allegation you can. In fact, I've tried to explain to prosecutors that they don't have to do that, that they are the plaintiff. They are in control as the party bringing the case as to what they allege, what claims they file.
But to that point also, they have the ability to ask the court whether or not to aggravate a sentence on that. So it's not entirely, you're absolutely right, it is judicial discretion to a certain point, but it is also part of the prosecutor's office to ask for aggravation on that.
Yeah. So again, that's part of the cultural change that we need to bring about in that office, is so that prosecutors aren't aggravating every single person that comes back there just because they have a prior. So if we're not alleging it and we're not asking for it, then the court can still do it, but that sends a pretty strong signal to the judge that we don't believe that's necessary, and we're the ones who are charged with doing what's right for the community. If we really want to fix it, that's going to require legislative change that changes what are aggravating circumstances that judges are allowed to consider, and what it changes the mechanisms of whether those allegations can be used at all, even when you think it's appropriate, even when that's what is required to protect the community based on the harm that happened in that case. When you've got Al Capone on tax evasion, right?
Sure.
So those calculations, though, those need to be made by our line attorneys, and those need to be made by the prosecutors who know those cases best, and they need to be made after we've brought a new conception of how we approach justice, which really isn't a new conception. It's the old conception. It's what we were founded on.
So we have seen across the country, we have seen in the last 2 years specifically, progressive attorneys being elected to county attorney offices and district attorney offices throughout the nation. One phenomenon that appears to that has appeared a number of times and has just appeared again, I was reading yesterday, is the bench coming back and stopping a progressive county attorney or district attorney from implementing a policy in this terms. Say, refusing to prosecute a low-level drug crime on somebody, or in a case that I saw yesterday, the judge refused to accept a plea bargain because it didn't include a term of prison, because the county attorney did not want this person to go to prison, which goes right into the very things that you're talking about. And when you're talking about culture shift in the county attorney's office, and you're talking about the way that you're going to prosecute and the way that you're going to seek from the court. So this gets into a gray area. This gets into a line of separation of powers. There's the executive department, which the prosecutor is an affect of or an element of the executive as law enforcement. And then the judiciary. Those are separate branches. But there's also the legislative branch, and the legislative branch is representative of the people. So there is this struggle and tension that our founding fathers had set up. And so I'm interested in where that line is on separation of powers in your mind for the Maricopa County Attorney's Office on between the MCAO and the judiciary in those cases that I've enumerated here moments ago, but also where is that line with affecting the will of the people through their legislature when they put crimes on the books and county attorneys choose not to prosecute them?
What an excellent and important question. Let me take it in two parts.
Sure.
So I think you got it right. There is a tension there, and it's intentional. There's supposed to be a tension because all of our government officials, jurists, legislators, executive officers, swear an oath. They swear an oath to uphold the law and to uphold the Constitution of our state and of our country. So it's incumbent on everyone. So at the end of the day, while it's the courts who have the final say in interpreting the law and the Constitution and saying this is exactly what this means, that's their function. The reason there's litigation is because those questions aren't completely answered, and there still is and there always will be a lot of gray area in there. So it's incumbent on our elected officials to uphold the law and to interpret it themselves, not in contravention of established precedent and what the courts have already told us. I'm not saying that we can say, well, I disagree with the ones who decide this and insert my own interpretation. I'm talking about in the gray space that's left. So everyone is supposed to do that, the legislators and the executive officers. They're supposed to, and there's supposed to be this tension, and we're supposed to take it to the courts when there's a dispute about how things are supposed to be done. So with the MCAO and the judiciary, the separation of powers says that it is the executive's function to faithfully execute the law, right, to carry it out. That means it's the executive's job to allocate resources. The legislature can give us resources. The legislature can give us resources for specific things and can even give really specific guidelines about what they want it to be used on and how. And if that happens, then that's what you do with that, right? And you take that specific guidance, you use it that way. But the judiciary doesn't have that power to tell the executive where to allocate its resources, where to spend its precious limited resources on how to represent the community. And even separately, just from separation of powers, as lawyers, it's our obligation to do what's in the best interest of our client, and courts shouldn't be telling us what that is. So what you're talking about, where we have courts saying no to efforts to typically dismiss certain kinds of cases who've been brought by previous administrations but are now no longer within your conception, within a harm-based, justice-based, community-oriented conception of justice, that's fundamentally unconstitutional in violation of separation of powers, in my opinion. And I think what we're going to see nationally is that's what's going to happen. Those courts that are doing that are catching a lot of blowback for it, and that's wrong. And although those courts get to decide that, they're going to get reviewed by higher courts, and we're going to see that you can't tell the plaintiff that the plaintiff can't dismiss the plaintiff's own case. That's their job. Now, if there is a problem with the prosecutor's office, the executive, carrying out the law that the legislature has created and told them that it's the will of the people to carry this law out, then that's what elections are for. Right? Elections are the function. Unless it's a very specific, clear thing that the legislature has created, we're setting aside $150,000 for you to create a diversion program that is specifically available to veterans, right? And you just don't do that. You use it for something else. Well, that's illegal. You violated the law. Sure. And so, and I think our current executive officer at the very, very top is struggling with something very similar to that right now. So elections are a big way we do that, and the legislature.
So there's been much discussion surrounding sentence reform in Arizona. There was just an event that happened earlier this week regarding sentence reform. There's legislation that's out there. Can you share your opinions regarding mandatory minimum sentences? And specifically, how do you feel the sentencing scheme impacts an individual's likelihood of rehabilitation and reintegration in society?
Mandatory minimums are a product of the tough on crime era. They were ostensibly passed, at least under the auspices of redressing disparities in the system, where certain segments of our community were getting worse sentences than others. But it hasn't changed that. It hasn't fixed that. Because there's still implicit bias in the system. It's just in the hands of the prosecutors now. It's in those offices instead of in the judiciary. So it's been an abysmal failure. Mandatory minimums create the trial tax. If somebody, is to exercise their constitutional right to a trial, and the case has been filed in such a way to give very significant mandatory minimums that the legislature's enabled, then people, innocent people, I've seen it time and again, have to make really, really tough choices. And sometimes they make the choice of accepting a conviction and admitting to a crime that they didn't commit, because it protects them from having to go through that process and risk losing their life, losing their relationships, losing their everything, and going to prison. And there's nothing, again, fundamentally un-American than that, than coercing people into pleading guilty. The cash bail system facilitates that. When you're already sitting in a box and you haven't been convicted, and you have a plea offer in front of you that says you can get out of that box and go on probation if you just accept a conviction on your record, it's massive, massive coercive pressure that forces people to pleading to things. So mandatory minimums are hugely problematic, and we're doubling down on them. Was it HB 2036 or 2046 right now that to raise the mandatory minimums for fentanyl possession? X is so dangerous, and so we need to raise the mandatory minimums to send a message. That's not how this works. People don't sit there and say, I was going to do that fentanyl because I'm addicted to it, but the legislature just changed the law and made it a little bit harder for me to, or made me have to go to prison for longer if I do, so let's do something else. That's not how life works. So deterrence theory has never been proven to be effective. And the mandatory minimums are eroding our fundamental foundational governing principles about individual liberty and innocent until proven guilty, and the right to a trial by a jury of your peers. We've got to get away from them. And we can do that. I can snap my fingers and do a lot of it by bringing about cultural change and specific policy implementations in that office to prevent us from jacking people up into category 2 and 3 so they have these massive mandatory minimums. But that'll only work as long as I'm in that office. We need our legislature to get on board with fixing our sentencing scheme. We don't need mandatory minimums. Our courts need discretion. They're the neutral parties. They're the objective ones. And we have a fantastic judiciary. There are so many great judges in Maricopa County on the Superior Court, on our Court of Appeals. And they know what the right thing to do in these cases is. We also need to get rid of the stacking ability, right? The Hannah Pryor situation where law enforcement can do a controlled buy one day and then also the next day just to force somebody into a prison mandatory sentencing situation, and empower our courts again. But that's going to be incumbent on the legislature. I can help in Maricopa County by exercising my discretion, but we do need good leaders down at the state legislature reforming this, getting rid of our mandatory minimums, moving to a maximum system where we say this is the most we think we should do in cases like this, and maybe here are some guidelines, like we do in the federal system, but ultimately leaving it up to the court to decide how those things work out. And defense lawyers will understand, and they'll advise their clients appropriately. This is a case where previously you would have gone to prison for sure. But given the facts and circumstances, given who you are and your background, and given all the reasonable doubt and other defenses that we can raise, there's a real good chance that even if we lose, the judge is going to exercise discretion and exercise some leniency in this case. And what we'll see is people will have more access to their fundamental constitutional rights. We will see more trials. And when we stop prosecuting at the felony level, some of the things that we need to not be prosecuting because it's making everything worse and it's costing us $1.2 billion at the Department of Corrections every year, when we stop prosecuting those, we will have the resources to focus on those more trials. And what I say earlier, lawyers like trials. Lawyers like it. So I think the prosecutors are going to be happy with that. I think defense lawyers are going to be happy with that. And I'm damn sure that folks who find themselves accused of something are going to be happy with that. Oh, also our judges.
So a couple of things that you've talked about a lot is the pressure, the coercive pressure of the cash bail system about the haves and the have-nots, the people that are left behind and incarcerated, pending the outcome of their trials or their plea process. Additionally, the stacking of charges puts an intense amount of pressure on a person because they're looking at these multiple sentences. The prior felony convictions, all of these things are enormously problematic for a person when they're facing the criminal justice system in there. One of the other elements that has historically been in Maricopa County is that you had a sheriff for 30 years in this county that made the jails the most difficult and inhumane place that you could possibly be. And the coercive pressure that was relative to that, I personally witnessed on multiple occasions people signing pleas just to get out of the Maricopa County Sheriff's Office because the conditions were so abhorrent. Part of the mandate of the Maricopa County Attorney's Office is to be the lawyer for that department and that division. Now we have a different sheriff now with a different mandate. That's certainly true. But Sheriff Arpaio is in the race to run again. And it's not just Sheriff Arpaio. There are other sheriffs. There are other people that come around and believe in that model that jail should be a horrendous place and that people that are not touched by the Eighth Amendment, they're touched by the 14th Amendment due process, and there's a lot less litigation on due process relative to conditions of confinement as there is on Eighth Amendment, which you don't get to unless you're sentenced to prison. What's the role of the Maricopa County Attorney's Office? What's the policy you want to initiate as the lawyer for that division when it comes to what you as a person in our society recognize are intentionally coercive elements and the undermining of what I think is the undermining of our criminal justice system through that pressure?
I agree with you, and that's such a fantastic question. I'm glad you asked it. People don't realize that the civil legal function of our county attorney is such an important job to advise our Board of Supervisors on policy, on what is legal and what isn't. There are issues right now where if we had other plaintiffs' lawyers paying attention to them, we'd be in the middle of massive lawsuits, and it would cost us all tons of money. But at the jails in particular, where it's about justice and it's about having really inhumane conditions that are coercive and undermine our justice system, we have a good sheriff in office right now, but that sheriff doesn't have a good lawyer advising him. It's important to put forth a candidate for county attorney who can serve in that function. I looked really hard at our prior county attorneys, and I couldn't tell. It's kind of hard to research somebody's career from the early 20th century, but I don't think we've ever had a county attorney with any substantial degree of civil litigation experience. So I'd be the first, definitely the first in the last several decades, so since the tough on crime era. And that's really important because that experience that I bring to the table will help me advise my client. And when my client is Sheriff Penzone at the jails and there are continued problems, one of the things you do when you advise your client is to tell them what's in their best interest, not just in this lawsuit that's come up because of some unfair condition or something else that needs to get solved, but it's to advise them about how to avoid that in the future. It's about how to mitigate that down the road. So just from like a responsible government perspective, it's important to have an experienced civil lawyer there to work with Mr. Penzone and say, look, we've got a problem here. And as your lawyer, I'm advising you this is how we should solve it so that we don't end up in costly litigation and so that you are no longer with these systems, which I again, I'm not accusing Mr. Penzone of doing anything, Sheriff Penzone, I should say, but so that it doesn't further create unduly coercive environments. I think things have gotten a lot better under Sheriff Penzone, and to the extent that there are still problems that come up, I have the capacity and the experience to advise him as his lawyer how to respond to those effectively, whether this is something we should settle instead of fighting, tooth and nail for, and then how to redress it in the future so it doesn't happen again, so that we create safe spaces in our jails when you do have somebody in the jail. And it makes all of us less safe and improves the administration of justice. Makes all of us more safe and improves the administration of justice.
All right, let's talk about a lot of people's favorite topic, marijuana. It's a big one. So efforts are underway to put marijuana legislation initiative on the ballot in Arizona in 2020. And while this remains a somewhat divisive topic, public support for recreational marijuana legalization continues to increase. What is your position on the decriminalization and or legalization of marijuana? Because those are two different things. And if there's no change in legislation during your time as MCA, if elected, would you prosecute marijuana-related offenses And do you support expungement of prior convictions related to marijuana? I know that's three questions in one, so take them as you as you want to.
I think it's relatively simple, though. Marijuana is not a crime. It shouldn't be a crime. And it has historically disenfranchised more people of color than on the other side, yet people, white people, black people, Latino people, indigenous people, all use marijuana at the same rates. So it's definitely something that I think is going to be legalized soon. And even if not, it needs to be decriminalized because we shouldn't be using our justice system to disenfranchise people. The expungement issue, absolutely. I mean, and that's another thing. That's a day one priority for me. We don't prosecute simple drug possession at the felony level, and we don't allege we don't allege simple drug possession priors to jack people up into higher sentencing categories. That's period. That's black and white. We have decades of this historically unjust system that has been operating to disenfranchise people and to criminalize and otherize people that needs to be redressed. And that's what I can do as county attorney. But that's a microcosm of what needs to be done. Our legislature absolutely needs to take a hard look at how to implement meaningful expungement practices and get rid of these convictions that are sitting on people's records, making them unemployable and making them incapacitated and preventing them from rejoining our society and contributing to the economy. Because it's making all of us less safe, and it's just bad. It's not smart.
Okay, so you said it there when you said that you're not going to prosecute low-level drug crimes, marijuana crimes. Here's a thing. I hear that a lot. I hear that a lot amongst the other candidates that are running for county attorney. I hear that across the nation. But here's one question that I don't see a lot, which is this, that the vast majority of drug convictions are not standalone convictions. They're achieved contemporaneous to some other criminal act. Because when you're talking about a lot of drug addict crimes or substance abuse crimes, or drug possession or substance possession crimes, you're talking about people that are addicted and are committing some other crime.
Not always.
Not always. But I think that the vast majority of them are.
And when we look at conviction records, I would disagree with you on this one.
Okay, go ahead.
Because do you know what plead to delete is, right? You know what plead to delete is? Plead to delete is a policy that we've been operating under at the Maricopa County Attorney's Office for some time. Okay. I believe it was implemented first by Andrew Thomas, but it kept on going, and it's still in place. It means that people plead guilty when they're coming out of Maricopa County, at least at Superior Court here. The default policy is that any settlement that you get to has to be to the most serious offense.
Sure.
On there. And the culture that the county attorney is operating under right now also seems to think that every single like, let's say there's more than one person who is harmed by an offense. Let's say it's a theft or something from a business, and there are two business owners. Then the what's in vogue is that we need a conviction for each victim too, and so that's a soft policy. It's a cultural thing, but but because of that, I don't buy the argument that's coming out of APAC, the Arizona Prosecuting Attorneys Advisory Council, that when we say there are people in prison for simple drug possession who are non-dangerous, non-violent, and their argument is that, those people are actually in there for other more serious things. They're in there because they were selling drugs or they were burglarizing houses. I don't believe that for a second. That's 100% false, because we've literally had a policy for 20 years to do the opposite, to convict of the more serious offense. So that's categorically false. And once we have access to this data, which unfortunately when it comes to in prison, a lot of that's when it's coming out of Maricopa County and sending people to prison, I can look at that. I can't see everything that's in DOC, though, because it comes from other places. But so I don't buy that argument. When people are, though, and it's true, though. What you say is not wrong. People do when they are at the bottom of that spiral, when they are at their lowest low in the cycle of abuse and addiction, and they can't get out of it. They do tend to start to commit other crimes. more serious crimes. It escalates some, and not always. Some people live their entire life just struggling with substance use disorder, and they never do anything to hurt anyone, whether it be a property offense or a violent offense. But when somebody is so far down the rabbit hole because of substance use disorder and how it has impacted their judgment and their ability to make rational choices, that they're actively hurting people, that's real crime that needs to be responded to. And I'm not saying that we don't prosecute those cases. I'm saying we need to be smart and take a look at the underlying cause. And I don't think for a minute that when I say there are 20 people, or the 20% of the people at the Department of Corrections are there for simple drug possession, for possessing roughly 2 sugar packets worth or less of some illegal substance. I don't believe for a second that any significant portion of that group is actually committed something else more serious, and that's the only thing they're convicted of because of a plea agreement. That's, I think, false.
Okay, so let me take the case where we do. Let's say that we take this particular scenario. We have a person that's committing a burglary. When he's arrested for the burglary, he or she is arrested for the burglary. He's found to be in possession of a gram of
We
heroin.
prosecute the burglary, and we
Okay.
look at other options. And if that person doesn't have other burglary priors that give us serious concerns, that person's never had an opportunity to be treated like a first-time offender. And with the money we save, by no longer wasting resources on the things that aren't dangerous, that aren't burglaries, then we will be able to create meaningful treatment programs and diversion programs. And sometimes it's so serious that diversion's not appropriate. But I'd like to do that as much as possible. But just because diversion's not appropriate doesn't mean that we can't find another mechanism to get to the underlying cause.
Sure.
Because that person is not going to be made better just by sending them to prison for the burglary. They're gonna get out, and if you don't treat the drug addiction, they're gonna recidivate. And burglaries are very, very dangerous offenses. In Arizona, when people own firearms, it's deeply ingrained in the culture of our state. If someone's in your home, the individual who's doing that's likely to get killed. That escalates things. Other people die. Very, very dangerous, very serious stuff. But the cause of it is medical. It's a medical crisis. So we have to address the seriousness of that crime, but it's really the responsibility of our Chief Justice Enforcement Officer to figure out a way to make sure that doesn't ever happen again.
Okay, so let's talk about budgeting. The state of Arizona is spending an enormous amount of money on prisons. Like you said before, it's $1.1 billion historical, $60 million a year over year for the last 3 years, about to approach $1.2 million. The state of Arizona spends less money on child safety and universities combined than we're spending on prisons. But that also happens at the county level. At the county level, we're spending an enormous amount of money to incarcerate people. Again, the cash bail comes into issue. But at the county level, you have 4th Avenue Jail, you have Lower Buckeye Jail, you have Durango, you have Towers, you have all these different jails that are operating and functioning. And that's a big budget appropriation that happens every year. Being elected MCA would grant you the opportunity to develop policies that impact these budgets. Can you share some of those policy ideas in relation to how they will impact the county budget at the county level?
I think we've already touched on a lot of them. We don't prosecute simple drug possession as felonies and send people to prison for that. We stopped doing that. We stopped prosecuting minor property offenses as felonies and sending people to prison for that. And we end cash bail. So immediately, day one, 35% of the influx from Maricopa County to the Department of Corrections is going to stop. That means 35% of the people who are being held pre-trial, and that's just the simple drug possession and minor property offense stuff. And let me clarify a little bit about the simple drug possession, or the minor property offense stuff. I do mean minor property offenses. I don't mean actual burglaries, like we just discussed, which are so dangerous to the community. That would be a disservice to the client, to the people, not to treat that seriously and figure out how to prevent it from happening again. I mean shoplifting, right? I mean minor property offenses, the things that we send people to prison for that we shouldn't be. So day one, we stop that, and that also cuts down the DOC budget by 20% immediately, because Maricopa County comprises about 60 to 65% of the folks that we're sending to the Department of Corrections statewide. So day one, that 20%, that comes out to $210 or $220 million per year that I'm going to be saving in our statewide budget. So then, the electorate's going to have to put a little bit of pressure on our executive officers, on the governor, and our legislature's going to have to work with them to reallocate those funds in smart ways. That's not within my purview. But that's a day one thing. And we're also going to reduce our prison population by implementing structural changes to prevent the racial inequities, the biases that give Black and Latino and Indigenous folks longer average sentences than everyone else. And we're going to reduce average sentences overall. And the legislature is going to help with that too. So that's not a day one thing, but that happens over time. And I really do think, coming out of Maricopa alone, I can reduce the prison population by 30% within my first year. So now we're talking about $320 million per year in a statewide budget. Locally here, with ending cash bail and with no longer prosecuting those things at the felony level and sending people to prison, that means we no longer have people sitting in jail for a year or 2 years until they get to trial or until the case gets settled. And we no longer have people serving those jail sentences that they don't need to be serving before they're ever even convicted, when they're innocent as a matter of law. That's going to save us hundreds of millions of dollars. Our jails are so colossally expensive. And then, as county attorney, I do have some control and say over what we do in that. Our board of supervisors, it's critically important that we elect a board of supervisors that understands the school to prison pipeline, that understands mass incarceration, that understands the historic inequities and racial disparities in our justice system, so that then, when we save that money, we can reinvest it where we need it most. I said earlier that education and opportunity are the only things I'm aware of that are consistently proven to reduce crime and recidivism. So we need to reinvest that money in our schools, our least funded schools. We need to reinvest that money in economic opportunity and development in those parts of our community. And that's what's going to reduce crime overall. So that's a fantastic question. And I think I'm going to be able to work with all of our county officials next year in 2021 to bring about that kind of change.
Criminal justice reform writ large. All right, so there's a lot of energy right now surrounding criminal justice reform, not only in Arizona but nationwide. Beyond what we've previously discussed, what other areas of our criminal justice system would benefit from reform?
Other than what? I'm sorry?
Other than the ones that we've previously discussed already. Is there any other areas that you're aware of that we could use some reform in the criminal justice realm?
Oh gosh, we've talked about so many things today. I think our legislature has a lot of work to do too. I mean, I have a very clear vision of how I, as an executive officer, can work to end mass incarceration, to bridge the gap between our communities of color and law enforcement, to hold government accountable and bring transparency and integrity back to the county attorney's office. That's pretty easy, I think. I mean, it's hard. You gotta win the election, but we're getting a lot of support, and people are excited about that. And we have a clear vision on how to accomplish it. But that's just an executive function. We talked earlier about the separation of powers, and that only lasts as long as I'm there, as long as we have a true reformer in office who understands our foundational governing principles. And these things happen in cycles. So down the road, if somebody whips up otherizing, antagonizing, anti-immigrant rhetoric or something else, then we can just end up back in this same situation. So our legislature needs to focus on this. Our legislature needs to remove these tools that they've created that are unnecessary. In my view, we figured out a long, long time ago all the different ways that human beings can hurt each other. And they haven't changed. For thousands of years, we've known that this is how it works. When somebody does something wrong, these are the ways that it happens. They were at common law before they were codified and statutory. We know them all. There's no such thing as new crimes. Yet we keep inventing them, and we have been inventing them for decades, and we've been making the penalties worse and worse for decades. Our legislature needs to get on top of fixing that and reforming, pulling back against some of those things, because we can and will end up back in this situation down the road. Even if I could be in that office for 30 years, but eventually I'm going to die and I'm going to be out of there. Whatever, however it goes, if I'm not reelected to a second term, if we don't elect me in the first place. So our legislature needs to pay attention to this. And we've got a lot of smart, committed reformers at the legislature working on it now. I think our Republican legislators need to pay attention to this, because the Republicans that I know, the conservative folks in our community, these aren't alien concepts to them. This is the justice reform movement is about fiscally responsible government. It is about individual liberty and limited government. These are conservative ideals traditionally. It's a weird time to be alive, where the interests of the progressive left and the conservative right happen to be perfectly intertwined. But they're doing the opposite. They're passing more mandatory minimums, and they're not working to actually address this stuff. Take a look at Oklahoma. A Republican legislature just passed a massive criminal justice reform overhaul, and it is incredibly popular in a conservative demographic there. So our legislature needs to get rid of all of these ridiculous, unnecessary tools that we have handed to our prosecutors that they don't need, and I encourage them to keep doing that. SB 1071 is one of my favorites. Senator Martin Quesada, ranking member in the Senate Judiciary Committee, filed that to repeal what's left of SB 1070. I think that's fantastic. Reducing our prison population, getting away from truth in sentencing, and creating meaningful opportunities for folks who are incarcerated to earn release credits. Critically important, needs to happen. There's another bill that's on the floor right now. I forget the exact number of that one, but it's to reduce the amount of time that if somebody does have a legitimate prior conviction, that it can be alleged to enhance somebody's exposure. Because people change. Can you imagine who you were 10 years ago today? I mean, a completely different person. Right. Even 5 years ago today. Like, imagine 5 years ago who you were then, totally different person. People can and do change, and we shouldn't sandbag them for the rest of their lives. And there are bills to kind of cut back against that. That's another part of the tough on crime era that brought us mandatory minimums that we need to unwind.
So you mentioned SB 1070. 10 years in, this is the home of SB 1070. 2016, we had a peak in rhetoric with the presidential election. Never been short on rhetoric in the state on anti-immigrant, others, as you said, otherizing language. Where are we, in your view, with SB 1070? And what is the role now of the Maricopa County Attorney's Office in affecting the law relative to immigration that is illegal?
There is none. That should be within the federal government's purview, and our federal government needs to do much better about that. SB 1070, there's still pieces of it that are left, but let's not forget that it was a political maneuver. It's part of our hyper-politicizing of our criminal justice system to do these things, to demonize and to otherize, and it's selling fear. So we need our electorate to start learning, and they are. Like, everyone I talk to about this is sick and tired of it. They're sick and tired of us politicizing criminal justice and using our criminal justice system as a cudgel. I mean, we live in a day and age where the President of the United States just last year suggested that we punish women, criminally punish women for exercising their fundamental right to reproductive liberty. That's got to stop. SB 1070 is like one of the worst examples of politicizing our justice system, and it has absolutely no place in Maricopa County, in Arizona, in the United States of America. And let's not forget that a conservative U.S. Supreme Court overruled almost all of it. So that was a bad idea when it started, and it's a bad idea today, and it'll be a bad idea tomorrow, and our politicians should take note. And hopefully the electorate stays as alert to those things as I feel like they are today down the road. I mentioned earlier that there's a bill on the Senate floor right now to repeal what's left of SB 1070. I think that is incredibly important because it's symbolic. Interesting thing, when you otherize and you demonize for political gain, you hope that the people you're otherizing and demonizing remain disenfranchised and remain disenchanted, and they never come back and make problems for you. That's one of the reasons Tough on Crime is so successful, because we disenfranchise people who are convicted, so they can't vote anymore. So the bad guy that you pointed the finger at can never come back and do anything about it. But I think Arpaio and Pierce and Andrew Thomas, they messed up. They messed up when they built this SB 1070 thing, this machine that brought national attention onto our backwards policies and how extremely down the wrong path we had gone. And it has created a generation of empowered Latino advocates and leaders, brilliant Latina advocates and leaders, all of us who have seen the worst aspects of how that demonizing and otherizing has impacted and damaged our communities. And we are all stepping up now because we're sick and tired of it. So the legacy of SB 1070 will always forever be a shame on the history of Arizona. But on the bright side, the legacy of it will also be that it has encouraged our Latino community to step up and take that power back.
So in addition to that, in addition to those people that you enumerated a moment ago, Arpaio and Russell Pierce and Andrew Thomas and that ilk, one of the main players in the room during the creation of SB 1070 was the private prison industry. Mm-hmm. That's the money. They were standing to have an incredible boom in population because of the way that SB 1070 was written. What are your thoughts on the private prison industry, where they are now and in the state of Arizona?
There's nothing more morally bankrupt, in my personal opinion, than profiting off of human suffering. And make no mistake, when we send people to prison, it's because we're punishing them, because we intend for them to suffer a bit, mm-hmm. right? And they do so particularly in Arizona, where the conditions are really, really bad. So when you have a company for profit that's traded on the New York Stock Exchange, profiting off of that, that's a huge problem, and it needs to stop. That money then comes into politics and it feeds bad ideas like that, mm-hmm. because those things then feed the private prison industry. And the folks behind that are the same folks who are behind the push against legalizing marijuana, the ones mm-hmm. who are opposing that because they own patents on synthetic marijuana. So it's for profit, and they're using our criminal justice system to make money. And they're selling us fear. It's all the same stuff, and it's absolutely got to stop. It's morally bankrupt, and we need to end it. I, as county attorney, will not have control over whether we continue to contract with private prisons, but when I end mass incarceration for Maricopa County and for Arizona, really, given how important and influential Maricopa County's impact on that is, and others start to follow suit because of it, when we end that system, we're going to have so much leverage to put pressure on our executive leadership to do something better with those resources that are now available, and to stop contracting with companies that are profiting off of human suffering.
Okay, so our last question. Well, and I really appreciate your time today on this. The last question that I have is, I'm a LD15, LD6 voter, wherever you want to go. I'm from Jay Lawrence's district. And I have voted for Russell Pierce, and I voted for Joe Arpaio for 30 years. And I have voted for Andrew Thomas and Bill Montgomery. And if I was living in Yavapai County, I'd be voting for Sheila Pope because I like her policies. Why am I going to vote for Will Knight?
I mentioned before that the justice reform movement is foundationally a very, very conservative concept. It's about having a smaller government and less interference with our personal lives, and it's about responsible, fiscally responsible government. You should vote for me because I am the most conservative candidate, because I'm actually willing to bring us back to our foundational roots as a government, to those things that you value: individual liberty, limited government, innocent until proven guilty, our core American principles. And the money that I'm going to save you, you'll see dividends on that. You'll see dividends on that in your community when we improve our schools, because we're near the bottom in education while we're near the top in incarceration. So we're going to flip that. And you're going to see that increases. One, it decreases crime, makes you safer. Two, it increases opportunity, and that helps our economy. So you're going to do better. We're going to do better. Everyone's going to do better. And we're going to be returning to those principles and values that conservatives hold dear.
Excellent. Will Knight, thank you so much for joining us. We really appreciate your time.
Absolutely. Thank you so much for having me, John. I really appreciate it.